presenting Dr. Faisal.
Okay, perfect.
Not sure if Dr. Faisal's
Okay.
here himself.
Okay, well,
But
interesting.
they will be coming.
They will be coming.
Yeah.
Oh,
It
my
says Dr.
bad.
Faisal, I'm not sure,
My
but
bad.
let's just leave it.
Okay, let's just see.
Nick, could you move the nameplate just a bit? A bit more? Good.
Good? Great.
And yeah.
So where's the waiting room then?
Yeah.
Yeah. Harsh weather outside and traffic as well.
I'm
Yeah.
Is the YouTube up?
Yeah.
Okay.
Did you come from Amsterdam? Are you staying there?
I stayed for like 2 days.
Okay. Alright.
This is my first time in Europe.
Oh, okay, wow. Yeah, hopefully it's a good experience. How long are you still staying? How long are you staying?
Until the 7th of December,
Okay.
I will go to Germany, Italy, Belgium, Luxembourg,
Okay.
France, and
Oh, that's a lot of
Switzerland.
ground. Okay, wow, that's a lot of ground. Making the most of it.
Yeah, so we'll just, I guess, wait 5 minutes and see.
Yes. Is Leslie able to hear us?
Yes, she can hear us now.
Perfect.
So yeah, once I already talked with her and I was telling her once she's leaving, we'll just talk to her and she'll
Yeah.
be able to hear.
Okay.
I'll just go outside and check if they're not waiting somewhere.
Okay, perfect. That should hopefully be like 5 minutes. And we can start. Sorry?
the Isle of Passion.
I'm not sure. I've heard 2 of them are around, but they haven't quite found the room yet. I spoke to Ali and he was saying that he saw two of them, but they haven't found the room. And one, Leslie, is joining us online. Yeah, so it's a hybrid format. Yeah.
Yes, because...
Yeah, we have two, so that's something. We can work
Yes.
with that.
So I think we have to start. Okay.
Yeah, okay.
And if there is any issue,
Let's just
I will
wait.
be in the coffee area.
Okay,
So please,
alright.
So let's just maybe wait for Mr. Warren.
Yeah.
Is that the link to the speakers?
Dr. Faisal,
Dr. Faisal Kurniawan and
then Tanaya and Layla.
Tanaya and
They're
Lisa.
a trio.
Okay, but Mark Anthony is here?
Yes, Mark Anthony is just gone to the toilet, yes.
Okay, so go ahead.
Yeah,
And as soon as I see any one of them, I will send them.
okay, perfect. Thanks a lot.
Thank you very much. And have a good session.
Yes, thanks.
Enjoy it.
So let's just wait for him then.
Yes. Yes, perfect. Yes, Mark, I think it's best that we just begin because
Okay,
the
no
stream is
problem.
already running and then we have Leslie who's joining us hybrid, so she's already here. So I'll begin this panel. Thank you for your attendance. I'm very honoured to be able to host this panel and I appreciate your attendance as well. Hopefully the other panellists join us throughout the session. But today's panel is essentially about artificial intelligence and how it intermingles with intellectual property law. So through the emergence of AI, there are several different types of intellectual property issues which arise. For instance, who should be the owner of a creative work, a film, a song, any kind of artistic expression that has been created through the use of an AI tool? What are the deciding factors? So we've received a number of contributions from the panelists discussing these kind of issues. One of the papers was, for instance, talking about how you can sue a doctor for malpractice if they've used a robot or if they've used an AI tool to help in surgery. Who can you put the liability on? Which are important questions which are arising and which the current legal landscape generally in the globe, but as well as in Southeast Asia, haven't really addressed yet, but these current legal systems need to either be adapted or new laws will probably need to be created in order to allow for a safe transition into this new AI world. So it's my honour to present Mr. Mark Anthony Manuel, and he submitted a paper basically analysing several different copyright laws in Southeast Asia and assessed what the key characteristics are of copyright law in Southeast Asia and what the distinguishing factors are and the key problems that AI presents towards the intellectual property scene in Southeast Asia. So I'm very honoured to have you, and I would also like to welcome you to the stage to present on your findings. And just to introduce Dr. Mark Anthony Manuel, he is an academic as well as a practitioner, so I'd like to refer to him as a pracademic, which is very useful for us here at Applied Sciences University to have somebody who hasn't merely done research but also has practical experience as an attorney at law. So thank you.
Good morning. Morning.
Good morning.
Morning. I will be speaking today about a very exciting, important topic about AI. Copyright status of AI-generated content, perspective from Southeast Asia. I see some mixed reactions and doubts on your faces, probably. You might be wondering, is this presentation made by AI? No worries, it is not. I created or wrote this But in the next slide, you will see that I was helped by AI. You can see on that image is the representation of the characteristic of AI-generated content and copyright law in the Southeast Asian region. So we are speaking about the 10 member states of the Association of Southeast Asia, or ASEAN, and plus one, Timor-Leste. Now, what we can see on this image is the representation of those countries and their approach to AI. And the question that we will be answering moving forward is, who owns the copyright? I wrote the prompts, but it is created by AI. Do I own the copyright over that image? Or does the AI ChatGPT owns the copyright over that image, or the developer? Does the developer own the copyright over that image? So we can say that there are different approaches of the Southeast Asian nations, the 11 nations, to AI-generated content. As you see on earlier on the image, it is a mixed bag. Why do you think we call it a mixed bag? Because different countries in Southeast Asia have different approach to AI. Unlike the European Union, you have a supranational, supranational organization. The ASEAN, or the Association of Southeast Asian Nations, is just a geographical grouping. So we don't have the same policy, and we also practice the principle of non-interference. What we mean by that? We mean by that we respect the sovereignty of each nation, and the policy, the regional policy of the ASEAN is merely a suggestion or a framework. Not the members are not required to implement it in their own jurisdictions. So different countries, different laws on artificial intelligence and copyright law. We also say that copyright laws, we also can say that there are different approaches in copyright law over AI-generated contents, because the AI was not even existent at the time that their laws were enacted or created. Take, for instance, the law of Malaysia. The Act 332 of Malaysia was enacted only far back in 1987. So that's 37 years, the year of my birth. So no one at that time knew that there would be such thing as artificial intelligence. Then, copyright ownership pertains to natural person. So there are a lot of different approaches to AI-generated contents in Southeast Asia. However, there is one similarity. They are all human-centric when it comes to copyright. What do we mean by that? They consider a natural person, as the owner of the copyright. So, no robots, no machines. Why is AI important in our region? Because there are a lot of study and research that it has a huge economic potential in the region. In fact, it could increase the region's gross domestic product by $1 trillion by 2030, providing a 12% boost to GDP, or an equivalent to approximately $92 billion. But then again, although there is a huge economic potential, as we say, there are still different approaches, and we will see with this research, the government AI readiness test by the Oxford Insights and the International Development Research Center, or IDRC, that there's a huge disparity among readiness of countries in Southeast Asia when it comes to artificial intelligence. We see that Singapore is at the second place among all nations, that's international, just a few points away from the United States, where the origin of artificial intelligence. And it is interesting to note that in 2020, they are 6th among all nations. In 2020, prior to the COVID pandemic, they placed like 6 or 7. In 2020, they are 4th, but last year, they are already at the 2nd place in the entire world. However, we see that there's a huge disparity. One of the 11 countries in Southeast Asia, Timor-Leste, is placed at 157, very far. And we see that other Southeast Asian countries fall between these two extremes, reflecting diverse levels of preparedness in the region. Malaysia is at the 23rd, Thailand 37, Indonesia 42nd, Vietnam 59th, Philippines at 65th, Brunei Darussalam 74th, the Laos 136th, Cambodia is at 145th, Myanmar at 149th, and Timor-Leste at 157. Common to this, to the copyright laws of these nations are that, as we mentioned earlier, they consider the owner of the copyright as the natural person, the author. So, Brunei Darussalam, for instance, they specifically mention that copyright owner belongs to natural person. In Cambodia, also natural person. In East Timor, although East Timor is a new country, one of the newest country to attain sovereignty. It's still unclear because up to now they don't still have any copyright law. They have already created a copyright law, however, it's still for the presidential approval. And they are not even member of the Berne Convention. Indonesia speaks of person or persons. And Laos speaks of natural person because it's under the Lao copyright law, it states that the copyright ends at the death of the author. And we know that machines do not die, right? Myanmar, it speaks of copyright belonging to natural person or legal entity. And in the Philippines, it speaks that author is a natural person. In Singapore, they said that authorial work belongs to a person. But we can see that Singapore is the most dynamic among these nations, being the second among all nations in the world to be AI ready. And there is a provision in Singapore copyright law, CDA, or the Copyright Data Protection exemption, which means that any person or organization can use data, even copyrighted data, to be used for data analysis. In Thailand, they mentioned that author means a person as well. In Vietnam, moral rights belong to a person, and we know that machines do not have any moral rights. So it is safe to interpret that under Vietnam law, the copyright also belongs to a natural person. But there is a unique provision under the Vietnam copyright law, which states that they give protection to computer programs and data. Now, in my study, I mentioned that there are 3 approaches in copyright status of AI-generated content. The first one is what I call the American approach. So this model focuses on the requirement for human authorship. Copyright protection is granted only if the work is fundamentally the product of human creation and creativity, with the AI serving merely as a tool. So under the American approach, the copyright belongs to the person, and even if AI or machine was used, the AI will only be considered as a tool. There's a very important case in the United States. It is a case in the U.S. Copyright Office. The title of the case is Second Request for Reconsideration for Refusal to Register Créateur d'Opéra Spatial or spatial theater opera, wherein there is an image. Actually, this image, the Theater Opera Spatial, won in an international art competition in the United States. But the image was created by use of Midjourney, an AI tool. So the U.S. Copyright Office stated that the person who gave the prompt has no right to register the same as his copyrighted work. However, on the flip side, we have the Chinese approach. Under the Chinese approach, copyright may be extended to the designer or user of the copyright. Because it demonstrates aesthetic choices and personal judgment. So they are quite diametrically opposed to what is the decision in the American jurisdiction. So under this approach, copyright will be extended to the designer or the user. So even it does not close the door for the copyright user to register for copyright. But then again, we have this sui generis protection model. Sui generis, it's a fancy Latin word, and it means of its own kind. So it separates the rules for AI-generated content and those rules for works created by human. So this model offers a unique customized approach from a protection for works created with AI assistance based on the level of human contribution. So my suggestion in my paper is we cannot apply copyright laws pertaining to human works to copyright laws pertaining to works generated by AI. And there are different considerations in coming up with a framework or even national law to be implemented in Southeast Asia. Why? Because there are different considerations. First, economic potential. We mentioned earlier that the GDP of Southeast Asia could be increased by $1 trillion by 2030, and that's a big economic consideration for all the nations in Southeast Asia or even in other countries outside Southeast Asia. Then, however, there's a diverse socio-economic and cultural context among nations. So we are one region. Southeast Asia is one region, but we are very diverse in terms of culture, tradition. So traditions in Singapore may not be applicable in tradition in Cambodia and Myanmar. So there is also a different perspective on AI. For instance, Singapore, Philippines, Malaysia, and Thailand already created or promulgated a national framework for AI. But then Timor-Leste, Cambodia, and Myanmar have yet to create their own national framework for AI. And there's also a varied maturity of intellectual property laws. So Singapore, for instance, is very mature when it comes to copyright law and intellectual property laws. But as we mentioned earlier, Timor-Leste, even now, has no copyright law in place. And they are not even members of Berne Convention. And then there's a balancing impact on businesses and creators. Why is this? Because any legal amendments must balance the interests of business leveraging AI for innovation with those individual creators to ensure equitable protection and promote substantial growth. But there are opportunities, as we mentioned. There's a huge economic potential for AI to be used in Southeast Asia. The idea that Southeast Asia could become a global leader in shaping international AI copyright law. But we, as we mentioned earlier, we must find a balance that could lead to huge economic potential while creating this framework for AI generated contents in Southeast Asia. So what can make Southeast Asia stand and to get these opportunities? So first is flexibility, adaptability, and modular approach. All countries must be flexible. So AI is a fast-growing, what can we call it, a fast-growing phenomenon in the world. So every nation must be flexible, but at the same time, we must be adaptable. We must adapt to the changes introduced by AI. And there can also be a modular approach, because as we mentioned earlier, different countries have different models, different perception, different cultures and tradition in their own jurisdictions. And what can make it stand out? So we can make potential for more collaborative approach and shared ownership. Will it interact with existing copyright regime, and we should also be tackling the issues on enforcement. Because one really interesting aspect is the potential for a more collaborative approach for AI development and copyright. Many Southeast Asian countries and Southeast Asian cultures have their strong tradition of communal ownership, like in the Philippines, we have that, and collective reaction, collective creation. Like in the film, the film maybe is produced not only by one person, but maybe produced by the director, the actors, the director of photography. So this could translate into legal frameworks that encourage shared ownership of AI-generated content. So my recommendation, as I mentioned earlier, is for a sui generis protection model, not restricting the ownership or not restricting the framework, the legal framework for AI-generated content into the American or the Chinese approach, but making a law or a regional framework that can address the issues based on the individual needs and approach of each country in the region. So there must also be clarity. Why clarity? Because we must have a clear definition and guidelines on authorship and licensing. Then, we must have clarity, as I mentioned, clear definition, guidelines on authorship and licensing. Because dealing with something as complex and fast-moving as AI is very complicated. Clarity is important because if the rules aren't clear, then nobody knows what to do. You get all the uncertainties, creators don't know what rights they have, businesses are afraid to invest, and legal professionals end up with a total mess on their hands. We need to spell out and put definitions. Well, it may sound simple, just giving the definition, but it is not. Where do you draw the line? How much human input is allowed before it's no longer AI-generated content? What's the balance between human creativity and machine output? You also need clear guidelines on ownership and licensing. Who owns the copyright for AI-generated content? Is it the developer, the user, the corporation that developed the machine, or some combination of the two or three? And how can these works be licensed commercially in a way that is fair to everyone? Fair to the investors, fair to the companies, and fair to the creators. And there must be balance. On one hand, we have to encourage innovation in artificial intelligence. We want companies and creators to feel that they can invest in AI and actually make money from it. Because if there's no incentive, then why bother? But on the other hand, we need to protect the right of individuals. We don't want AI to lead to exploitation in the region or to the destruction of cultural heritage. And finally, there must be balance. Adaptability, sorry. It must be adaptability. AI technology is changing so fast, so we must also adapt and make adjustments as it grows further and further. Thank you very much for listening, and I hope you learned something today.
Right, thank you, Mark, Anthony, Manuel, for that thought-provoking presentation and the interesting recommendations on how copyright could be addressed when it comes to AI, particularly with regard to the collaborative ownership. I just had one question that I still thought of, as your presentation was very optimistic, it seemed, of the potential of AI. Do you see any threats regarding AI? So any potential things that could go bad in relation to artificial intelligence? Because in the EU, for example, we now have the EU AI Act, which in a sense demands that AI tools are transparent about how they use the inputs, and also make sure that they take into account privacy of individuals. Is there any kind of such regulation in Southeast Asia?
In Southeast Asia, we still don't have a specific framework for the region, but specific countries have their own national framework. For instance, Singapore, they have their own national AI framework, which has become the model not only in Southeast Asia but in the entire world. But the threat that I'm thinking is the fact that if we will not be going to adopt and make a framework which is balanced, then it might affect the individual authors. Their works may be they will not benefit from their works if we make a framework which is AI concentrated.
Mm-hmm. So then it could be that they can't exploit their own creative works.
Exploitation of the creative works of the persons.
Okay, thank you a lot. Do we have any questions from the audience that may have arisen? Yes, it's...
Janusz Franz from the OECD. Thank you very much for that very insightful presentation. I have several questions, which to me, first of all, I would maybe want to get your thoughts on the definition of AI-generated content, because first of all, we might want to think about what is the definition of AI specifically in this context. I think that in many cases we might be talking about generative AI specifically in this case, but AI has been kind of a method even before ChatGPT. So what would be your thoughts on how do you define AI-generated content? The second point is, I was wondering if you could maybe give us a bit of thoughts on how is this question on copyright and AI being addressed in international institutions, for instance, WIPO. You mentioned the Berne Convention, but also copyright is treated in the WIPO Copyright Treaty, the WTO TRIPS Agreement. What do you see in terms of gaps in those international instruments when it comes to AI and copyright protection? And the third point, I think, to me at least, there is maybe two questions when it comes to copyright and AI. One that you tackled in terms of copyright protection of the content generated by AI. But there's also a second dimension before that in terms of training AI and what sort of data that AI is using in order to train itself. And that data might be subject to copyright protection. So could you maybe give us a bit your thoughts and thinking on what that second dimension would look like? Thank you.
Thank you for your questions. As I mentioned before, in general, a short answer for the definition of artificial intelligence is these are works or the intelligence created by machine. So, intelligent work created by machines. But in the context of ASEAN or for the countries in the ASEAN, they must formulate the definition of AI, generated content, not from any countries or any supranational organization, but they must develop the definition considering their economic and cultural diversity. So that's, in general, the definition of AI for me is it is the works or the machine that can create products of intelligence. But then again, as I mentioned, the definition must be written by the countries, by the country, specifically addressing the issues, the economic and the cultural issues in that country. So the second question you have is
On the international agreements.
the international agreements on.
Like the right.
Yes, there is an issue with the sui generis approach because I understand that under the Berne Convention, they still consider copyright as works generated by human intelligence. So, under the Berne Convention, if you are a country signatory to the Berne Convention, then you cannot adopt or create a law contrary to Berne Convention. So, if you are a member of that, it would seem to me that your definition of copyright must be something created by human creativity. And then the third question is.
Sorry, if I can maybe just elaborate a bit on the second one, because I think the international discussions on this specific issue is very important, because AI-generated content is inherently global these days. So we are watching movies, listening to music. It's not so much domestic, it's much more global. So I think the role of international organizations and a harmonized international framework is very important for copyright protection in this domain. So are you aware of any discussions at the WIPO, for instance, that are happening this issue?
I think there are dialogues. Even in Southeast Asian nations, there are dialogues regarding the definition of copyright, considering the emergence of artificial intelligence. But as of now, there's no concrete legal framework. Why? Because AI grows every day. It expands and expands. So you cannot stop a moving object at this instance. So it's fast moving. So I think what they are considering is creating a framework that is adaptable and flexible. That there is a framework, a general framework, but then again you can still adjust the framework to suit the growing changes introduced by it. The third question. Sorry.
Yeah, so the third question was a bit about the second dimension, which comes in the face of training AI. And we know that big companies, Google, Amazon, they have a tremendous amount of raw data that they can use to train AI, which puts them in a competitive advantage compared to smaller companies that might not have that ability to get all that data. So the question is, in the interest of balance between innovation and copyright protection, should there be a possibility for smaller companies to access data that might be copyrighted? So the question that I have is, what is the extent, or what are your thoughts on the copyright protectability or the use of copyrighted protection for training AI, and what is the scope maybe of exceptions in this discussion?
for instance, in Singapore, we have this copyright data analysis approach. It's actually a provision in the law of Singapore that they allow the use of even copyrighted data to train AI. My personal stand on that is there must still be a more research because politically, I think because big companies have this, big companies are in a better position to use it and develop the AI when they use copyright data protection in using their in training their AI. But I think it would be very difficult, especially with countries in Southeast Asia, because big companies have that power that smaller companies do not enjoy.
Yeah, so many thanks for your questions. We'll get to the other audience questions towards the end of today's discussions. We do have some other speakers who will present. But thanks a lot for these insightful comments and the question about training data sets. It's also very profound. There's cases between OpenAI and New York Times that are still ongoing. So in my opinion, the US will be quite a forerunner in determining on a global scale how AI can really be regulated when it pertains to copyright. I believe we have two of the panelists up here still. Yes, could I please ask you to join? So this is Leila Makfira Andavetna and Tanaya Anidita Vala. And you did a work alongside Dr. Faisal, as far as I believe, on basically how robotic surgery and how, if you use AI or robotic tools during surgery, how can one hold the doctor or the AI liable for medical malpractice? That's always an interesting liability question, and especially when it pertains to who should be responsible for the use of AI. Do you have a presentation? Yes, perfect. And I'd like to encourage you to come forward onto the stage. Many thanks for your presence. I'm pleased to meet you. I'm Sam. I'm a lecturer at the Intellectual Property Law here. Sam, nice to meet you. Then we also have one more speaker who will join us online afterwards, and then we'll open a more broad discussion where the audience can ask more questions and we can get into some profounder topics. So many thanks. Do you want to present generally what your findings were for today's panel discussion?
Sure.
Yes, many thanks. Then thank you.
First of all, am I visible? Because I seem to be really short, so if I'm not visible, I can just move aside. So, hello everyone. My name is Tanaya and I'm from Indonesia. And I'm along with my co-author, which is Laila. And we have another co-author, which is my professor, but he cannot attend today. Yeah. So, on today's conference, I would like to present regarding preserving the intellectual property rights landscape in AI-enhanced robotic surgery, which is, we will more talk about legal perspective from Indonesia and Southeast Asian countries. Okay, first thing first, we should know that robotic surgery is a robotic assistant surgery that will help the doctors to perform robotic surgery. And this robotic surgery is actually created by a human, but somehow it is AI driven. So this robot is supposed to just help the doctors in like minimizing the risk, being minimally invasive in doing the surgery, and it wasn't supposed to perform alone, so it has to be controlled by the doctors. And as we can see that here we have the history of the robotic surgery itself. So this one in 1985 is the first documented robotic-assisted surgical procedure occurred by the development of the programmable universal machine for assembly, or PUMA, for a brain biopsy under CT guidance. So here, even though that this is the first robotic surgery, this is not AI-driven, but this is the first robotic surgery that has came in this world. Yeah. And for the second one, because we are going to talk about the Southeast Asian, specifically Indonesian, so we have to get into the history of the Southeast Asian, robotic surgery in the Southeast Asian, which is first introduced in 2013 in Singapore, followed by Indonesia and Thailand. And then in 2017, this is the first AI-assisted robotic surgery that took place in here, actually, in the Netherlands. So yeah, even though that this all came before the first AI-assisted, we will focus more on the AI-assisted robotic surgery. Okay, and in Indonesia alone, Indonesia actually already really using robotic surgery a lot lately. For example, in 2022, which is Indonesia has successfully operating a surgery with an AI-assisted robotic surgery, and then we have in 2023 and 2024. And in fact, if you can see in here, Indonesia has handled more than 100 cases using robotic surgery for a variety of conditions. Okay, so as I told you before, that robotic surgery only intended to help the doctor instead of operating alone. So this is like the more background on the robotic surgery, which is even though that robotic surgery is an AI-driven, it can reduce malpractice risk through AI-driven precision, enhancing healthcare quality, and however, despite its advanced stages, malpractice can happen during surgery in using robotic surgery, AI-driven robotic surgery. Yeah. And on today's conference, our paper has objective, which is, it has three. The first one is to assess the IP protection nuances towards AI-generated inventions to ensure the best suited form of protection for a specific innovation. And the second one, the patentability of innovations in robotic surgery. And the last one is the legal framework on liability and dispute resolution in connection with malpractice claims. So before I continue, I would like to explain on why patent and robotic surgery, AI-driven robotic surgery is like really important in Indonesia. Is because up until now, in Indonesia, even though that we have already performed a surgery with a robotic surgery, we haven't filed a patent for the invention of the robotic surgery itself. So instead, we brought a robotic surgery from like the United States, which is the Da Vinci robot, which is a very known robot surgery assistant. So therefore, we would like to give a perspective on how the inventors should like file its own patent in Indonesia, because it can be really beneficial for our economics and also in cases of liabilities. So before we talk about the patentability of robotic surgery, we have to know that the international legal framework for patent, we have three, which is the Patent Cooperation Treaty, TRIPS Agreement, and also the Paris Convention. However, in today's conference, I will focus more on TRIPS Agreement because Indonesia itself has ratified the TRIPS Agreement. And so on Article 27.1 of the TRIPS Agreement actually also talks about the criteria of what is something that can be patented, which is it has to be like novel, inventive step, and industrial applicability. But however, the TRIPS itself leaves the criteria for protection undefined. So it allows WTO members to decide them within their legal systems and practice. So this means that because filing a patent is not extraterritorially applicable, so we have to focus more on the Indonesian law regarding this, regarding how to file a patent, how to patent a robotic surgery. So we will focus more on the Indonesian law. First thing first that we have to know, even though that Indonesia has used robotic surgery, up until now, Indonesia, there is no specific regulation regarding AI or AI related. Although we have one, which is a circular letter by our Ministry of Communication and Information, but a circular letter is not binding, so therefore, up until now, Indonesia does not have any regulation regarding AI or anything AI related that is binding. So, first thing first, that under Indonesian patent law, which is the law number 13 of 2016, which is the law that we ratified from the TRIPS agreement. Technically, we have the same regulation with the TRIPS because it is ratified from them, adapted from them. So first, it has to be like the criteria of the patentability itself is the same with the Article 27.1 of the TRIPS agreement, which is it has to be new, novel, and applicable to the industry. And for the time span itself, it's also the same with the TRIPS agreement, which is 20 years for a standard patent and 10 years for a simple patent. So, as we all know that AI has been rapidly increasing, like the use of AI has been rapidly increasing, like everyone is using AI nowadays to the point that the healthcare field is using AI for a lot of things. For example, like robotic surgery itself, and then the screening of disease that they tend to use with AI. So Indonesia is currently proposing an amendment to the patent law because in the last patent law, in the current patent law, Indonesia itself does not qualify a software invention to be protected under the patent law of Indonesia. So therefore, in the draft bill that we are currently amending in Indonesian patent law, it includes an expansion that Indonesian patent law will soon can protect the invention that includes software, solely software. Next. Okay, so because robotic surgery is a technology, a health technology in the healthcare field, in Indonesia, if we want to use robotic surgery or other health device, we have a thing that is called health technology assessment. So it is regulated under the Ministry of Health's regulation number 51 of 2017. And this is basically a framework that is developed with WHO, which requires all new medical devices to undergo true evaluations of safety, efficacy, socio-economic impact, and replicability in other countries before receiving market approval. Okay, so before I jump into the dispute resolution, even though that we talk about AI and patent, however, in Indonesia, up until now, there has not been any cases regarding malpractice in case of robotic surgery. So this is only to expand the discussion. So as we all know that, for example, that in the US, there has been, as extended to my knowledge, I have known 2 cases regarding malpractice in the US, which is conducted by a robotic surgery, and it tends to not protect the patient. So this is just to expand the discussion on, in any cases there are malpractice without regulation regarding AI, without regulation regarding AI related, not only just AI, but AI related. How can Indonesia solve this case? Yeah, this is more of a normative approach. Okay, so under Indonesian law, malpractice is divided into 2 categories, which is first, we have administrative and criminal, but of course, because we are talking about the dispute resolution, we will more focus on the criminal offense the malpractice in the criminal offense category. So, as we all know that in criminal law, if we want to bring something into the court, if we want to solve a dispute resolution, it has to have a legislation right. So, regarding malpractice, we have Indonesian health law, which is law number 17 on 2023. And it says in the, this one says no article, but it's actually Article 308. Health workers may be subject to administrative action if they engage in conduct that is prohibited for health professionals, whether in light of their professional oath or their oath as health practitioners. And then below that, it has another paragraph actually, which says that in any cases that, if I'm not mistaken, but it's basically saying that if health workers conduct a malpractice, it also can be categorized as criminal offense. And if the health worker is proven to do the malpractice, and so we will refer to the Indonesian Criminal Code. Okay, because there has no been cases, as I said, that's why I'm taking this approach to assess the law itself. And in cases where malpractice resulted in a serious injury, oh, wait a minute, I need to explain that. In Indonesia, malpractice, criminal offense in malpractice is separated into 3 categories, which is first, malpractice that is resulted into death, and second, serious injuries, and lastly, minor injuries. And this one, we have our articles separated. So for the death, for the malpractice that is resulted in death, is regulated under the Article 360, Paragraph 1 and 2 of the Indonesian Criminal Code, which basically said that, okay, can I quote the regulations? So yeah, so we don't have to read. Okay, so basically Article 360 stated that anyone whose negligence results in serious injury to another person shall be sentenced to a maximum of 1 year imprisonment, and anyone whose negligence causes injury that temporarily incapacitates another person or prevents them from performing their duties shall be sentenced to a maximum of 9 months imprisonment or a maximum 6 months detention, or a fine of up to 4,500 Indonesian rupiah. So that was the article for the injuries. So in any cases that a doctor perform malpractice with a robotic surgery, it can be categorized as a criminal offense under this article. And then for the death, for the malpractice that is resulted in death, is actually regulated under the Article 359 of the Indonesian Criminal Code, which just said that anyone, okay, so it says that anyone whose negligence results in the death of another person shall be punishable by a maximum imprisonment of 5 years or confinement for a maximum of 1 year. So it only has like different criminal sanctions, yeah. And there's one thing that should be considered, that in any cases that maybe the robot is like the one who is malfunctioning, but in Indonesian law, since we don't have any law regarding AI or anything that is AI related, in like criminal offense, so in order for someone to be sentenced under this article, it has to fulfill this cumulative element, and the first one is there must be a human act. So in any cases there are malpractice conducted by a robotic surgery, even though that it is like malfunctioning, the one that is gonna be liable is the doctor itself, because Indonesia does not have regulation more regarding the use of an AI technology. And to expand the explanation, we have the second point, which is the act must be consistent with the provisions contained in legislation. And the third one, there must be evidence of fault on on the part of the actor, and then the act must be against the law, and the act must be subject to legal sanction as stipulated in legislation. So I think that's it, and we have recommendations that for Indonesia to actually make a regulation regarding the use of AI technology, because nowadays the use of robotic surgery itself in Indonesia has been increasing a lot, and to minimize the malpractice, such as the liability, so it doesn't have to be fully liable on the doctor, and then to protect the patient in any cases of maybe there's a data breach, because if you want to use a robotic surgery, the doctor itself has to put the data in the robotic surgery so the robot itself can assess what is the possibility, what is the outcome of this surgery, like that. And we also think that, so in all, we think that Indonesia should regulate an AI regulation, and also regarding that patentability, we encourage that Indonesia and all Southeast Asian countries should make regulation regarding patent that is related AI. Because robotic surgery itself is not like AI generated, because it is created by a human, but somehow the technology itself is assisted by an AI. So yeah, I think there should be more clarity regarding the regulation regarding patent and AI. Okay. I think that's all. Thank you for
Many thanks for your profound presentation and also interesting research paper. I know some of you probably have some questions, but in light of the time, we'll move on to the last presentation, which will take place via a hybrid format. So the last paper was submitted by Leslie Osencia, and I think she's streaming in from the Philippines, and she wrote a very interesting paper regarding AI authorship and copyright in the Philippine art scene. So essentially, if AI creates a painting, who is actually then the author of that painting? So that's an extremely difficult question to answer. However, Leslie Osencia tried to have a go at addressing these issues in her profound research. Are you able to hear us?
Yes, sir. I could hear you from here, from the Philippines.
Okay.
Allow me to greet everyone there, to greet the esteemed members of the organizing committee, those joining us who are present there, also online, and the panelists who gave us very interesting, very engaging lectures. With that, sir, may I proceed to share my screen?
Yes, absolutely. Has she been granted permission? Do you know?
Yeah, she
Okay.
is.
All right.
Should pop up.
Yes, it is loading now. So thanks a lot. Perfect. Okay, then the floor is yours. Thank you for your contribution.
Thank you, sir. Artist Artificial, Dissecting AI Authorship and Copyright in the Philippine Art Scene. A pleasant day to all. I am attorney Leslie N. Taruc Orencia. AI-created art versus human-created art. There looms a divide here in this side of the Philippines. Today, ladies and gentlemen, I invite you to look into a scenario that transpired in September 2024. It all began with a post from a Facebook page, and it drew criticisms because of the apparent involvement of AI art. The post in question featured entries in a DG Poster art competition, one of which was an image allegedly generated using AI. The root controversy, the artist who submitted the AI art received monetary incentives for her participation in the said competition. Criticisms on the electric cooperative's recognition of the supposed AI-generated artwork were such as, how will you expect artists to be motivated to create meaningful, quality, and inspiring works if their efforts would be equated to that of a machine? On the other hand, in defense of the AI artist, an online user called the critics as hypocritical and even made reference to AI art as a postmodernist art. Art, a work that embodies our thoughts and our emotions. It reflects our being and serves as a window to the soul of its creator. Artificial intelligence hailed to be the new frontier, pervading lives, including art. And in the midst, there lies a divide between tolerance and rejection. This is palpable in the call for answers in the human authorship versus machine authorship debate. This only means that there is still indecisiveness on the treatment of AI in the Philippines. Philippine laws on copyright, though not necessarily defining itself, reference instead literary and artistic works as original intellectual creations eligible for protection. This is provided for under Article 172.1 of the Intellectual Property Code of the Philippines. It is then very apt that this era of artificial intelligence, familiarly AI, was beckoned in 2022 with the introduction to the mainstream of the unnaturally made poem or painting, oftentimes indistinguishable from their counterparts, something revolutionary, yet still something raw. Accordingly, this now presents a dilemma, both of ethical and legal consideration. Can such a creation be deemed art, at least one that is copyrightable under Philippine laws? In the Philippines, although the Intellectual Property Code protects the rights over artistic work, it does not explicitly address AI-generated images, which leaves a rather concerning gap in its legal framework. The debate which subsists until the present revolves around discussing whether AI-generated work could be classified as art under the copyright laws of the Philippines. While AI-generated art appears to be a new phenomenon, its origin can be traced back to the 1970s, when artist Harold Cohen explored the use of AI for creating art. However, as AI is increasingly getting capable of replicating or even exceeding the capabilities of human artists, the ethical and legal frameworks that govern artistic creation are now accommodating the new realities. For instance, AI algorithms can now produce paintings, generate music, create novels, and compose poems. This emergence of AI-generated art has since triggered debates in the field of copyright and authorship. Interestingly, the Berne Convention for the Protection of Literary and Artistic Works considers artistic work to be eligible for copyright protection, but only if there is an original author behind the intellectual creation. However, AI-generated content complicates this criterion, as it is unclear to whom this right should be rightfully and legally granted. This question has since been the core copyright dilemma. Another question posed is this: who should be more entitled to such rights? The programmer, the person who entered the prompts, or the AI itself? Other than the legal confusion over authorship, AI-generated work involves ethical issues as well. For instance, AI-generated work is said to undermine human creativity, devaluing the role of human artists and displacing them from the creative industry. The potential for AI-generated art also involves concerns over plagiarism and intellectual property theft, particularly in countries like the Philippines, where such problem, while yet to be codified as a specific crime, but nevertheless finds similar basis in the intellectual property code provisions on infringement, is rising in the creative industries. Thus, with the intellectual property code lacking provisions for AI-generated art, there is a necessity for new laws or amendments to address this protection. In the legal landscape of the Philippines, laws and jurisprudence are replete with discussions on intellectual property. Moreover, with the advent of AI in the recent years, more legislation in the form of House bills are becoming more common. Aside from the IP code, the following tables, relevant legislation, and focus areas concerning AI and intellectual property in the Philippines, highlighting existing legal gaps in copyright protection for AI-generated works, are shown here. At this juncture, it is recalled that the United States District Court in the District of Columbia promulgated Thaler versus Perlmutter in August 18, 2023, incipiently paving the way for future cases on AI authorship. Plaintiff in that case is a developer of computer programs which utilize AI and which boasts the ability to create visual art akin to one made by human hands. The contested AI system in this case, called the Davos, created a photograph which is called A Recent Entrance to Paradise, a hollow visual of vague purple flora surrounding what appears to be train tracks. Significantly, plaintiff sought copyright protection over the image but was denied by Judge Beryl A. Powell of the U.S. District Court for the District of Columbia by reason of the absence of human involvement, which is a bedrock requirement for copyright. I'm sharing here a presentation that compares U.S. and Philippine copyright laws and discusses potential implications for AI-generated works within both legal frameworks. Further, in Pearl and Dean versus Schumart, petitioner is a manufacturer of advertising display units called light boxes, which copyrighted its technical drawings under the category of pictorial illustrations. The Supreme Court in this case emphasized the concept of copyright protection as one granted to original intellectual creations. In Habana versus Robles, petitioners successfully protected their copyright over their written textbooks, with the Supreme Court acknowledging that the purpose of copyright books is to give protection to the intellectual product of an author. Overall, the focus remains on human-created works, for copyright protection and AI-generated work lies outside copyright eligibility in both the US and Philippine jurisdiction, requiring a well-coordinated effort at an international scale. It is realized that many of the risks involving AI are inherently international in nature. Thus, international collaboration is necessary in order to address these growing concerns. For example, the Bletchley Declaration, a global agreement held in the AI Safety Summit in England in 2023 by 28 countries including the Philippines and the European Union, acknowledged the need for shared responsibility and cooperation on AI safety. The declaration proposed a two-pronged agenda. One focused on identifying the shared risks of AI, and another on creating cross-country policies to abate such risks. The WIPO Copyright Treaty, to which the Philippines is also a signatory, is another global agreement that aims to protect the rights of authors in the digital environment. Finally, The European Union Artificial Intelligence Act, while without participation from the Philippines, but nevertheless presents a strong case for setting precedents, establish obligations to providers and users of AI alike in an attempt to mitigate the risks of the technology, all the while recognizing the tiers of AI risks that need addressing, from minimal, unacceptable, and high. Yet the overall analysis presented on the screen reveals significant gaps in addressing copyright and authorship for AI-generated content all over the world. This highlights the need for future comprehensive laws to globally address intellectual property concerns in creative industries involving AI. As discussed, the process of creating AI-generated images involves a type of technology designed to scrape millions of photos from private databases, which in turn detect patterns and correlations, and as a result, create new images corresponding to the prompt written. Another talking point that may arise is the morality of taking over the role of human artists. With the advent of AI-generated art, human creativity and the creative jobs that come with it is at risk of being devalued, if not already devalued, by displacing and undermining them from the creative workspace. Thus, both ethically and legally, the concept of AI art presents a conundrum. In the Philippine context, these issues challenge human-centered artistic definitions and intellectual property protection. And cases like Thaler versus Perlmutter and Pearl and Dean versus Schumer further stress the importance of human creativity and ownership for copyright eligibility. Now we go back to the conflict I earlier presented. As opinions differ, attempts to minimize the chasm can be seen in the recent boom of House bills tackling issues on AI. Hence, a steady rise during the current incumbency of the 19th Congress of the Philippines, about the same time when AI became rampant in the country. One House bill stands, however, from the others as far as copyright is concerned. House Bill 10546, known as an act promoting awareness for the intellectual property rights of independent artists, seeks to strengthen the independent artists' control over their intellectual property. Discernibly, this bill makes no discussion on AI. However, stark is the emphasis made on the intellectual property rights of independent artists, something that is lacking in the other House bills. Again, in stark contrast with other House bills, contextualizing AI protection in the lens of employment and labor only. Conversely, significant also is the bill's lack of authoritativeness. Nonetheless, one can optimistically conjecture that this bill will be the first step for the protection of artists, employed or independent, from the effects of AI. For example, the bill's call for awareness, coupled with the authoritative power of the bills pending before Congress, can pave the way for the recognition of the supremacy of human authorship, the authentic and not the imitative one. Based on the overall analysis, the study concludes that the Philippine copyright law is currently disconnected from the rapid development in AI technology. Noting the gap in the existing legislative framework, a compelling need to establish clear legal definitions surrounding AI-generated content is noted. Legislators must develop comprehensive legal definitions encompassing traditional artistic expression forms, along with emerging technologies to preserve the rights of human artists. This may also require defining the copyright scope as to AI-generated work and establishing ownership criteria, considering all key contributions. Future studies may explore the effectiveness of current international regulations on AI artwork and its specific applicability in the Philippine context. Ladies and gentlemen, it is my pleasure to have been given the opportunity to present before you. This study entitled Artist Artificial is an effort to contribute to a topic that is said to hold the future. This is on the hope that any information shared here today will be worthy of reflection. Thank you.
So, many thanks, Attorney Leslie Taruk Orencia, for your fantastic and creative presentation. I just have one question as your PowerPoint was particularly creative. Did you make use of AI tools when creating your PowerPoint presentation?
Yes, sir, I did.
And
This just shows, yes.
I have a follow-up question then. According to Philippine law, who would then be deemed the owner of your PowerPoint presentation, and what would be some key factors in order to determine who is the owner of an output from an AI tool?
Well, if we are to use the Philippine law, sir, the owner as to this presentation is not me nor AI. I could not apply for a copyright of this presentation because the bedrock of copyright law in the Philippines is that there should be that human involvement and creativity. However, in this case, I had to use AI to make my presentation palatable to the viewers. But to answer your question, sir, I cannot ask for a copyright of this presentation under the Philippine law.
Okay, many thanks for your contribution and your answer to my question. I generally now want to create a broader panel discussion, so I'm addressing my questions towards the other panelists in the room as well, that I hope you can see via your stream. But generally, through everybody's fantastic contributions, we seem to come to this general consensus about that an important part of copyright and AI is this idea of human ownership, or some kind of human, that ultimately the human needs to be the owner, or the human needs to be responsible. Why is that? Why do we put this focus on a human? Because, for example, if we look at corporate law and we come up with concepts such as legal personality, that's also an artificial person. So there we do talk of potentially this possibility that a non-human can have legal personality. Why with regards to AI, do we focus on the human as such an important factor? This could be a philosophical question, it could be a simple question.
From time immemorial, we consider copyright as human creativity. So you cannot define copyright without the human on it. So that's why.
Yeah, so to do with the human creation that it comes from.
That's why I propose a sui generis approach. You will apply copyright law to humans and then create an intellectual property legal framework for AI separate from human creativity.
Okay, many thanks for your answer, Mark Anthony Manuel. Do we have any other thoughts?
From my perspective, the essence of intellectual property rights is essentially giving the economic benefit to the, let's say, if we talk about patent, so it's to the inventor. If we talk about the copyright, it might be the author or the creator of the work. So if we talk about comparing a person as in us with an AI, we are the ultimate receiver of the economic benefit that derived from the AI. If the AI it's a system, it's a machine learning system. So if we were to grant this economic benefit to the AI, they're not gonna do anything about that, logically speaking. So I'm sharing the same view with the professor here, that we have to create a separate legal framework that protecting and granting benefit to the human based on the economic value of any invention and also the AI. And this also maybe, not maybe, but like ultimately also affect the legal liability of the AI versus us as a human being, because they are not here. They are like a system. They are intangible. So it needs to be separated and it needs to be governed as nowadays, because it's growing and we cannot just stop and just wait for any problem to occur, and we don't really have a legal system. But it's really interesting to know that we have, as you have mentioned, we have a consensus here that in the Southeast Asian countries, including Philippines and my country Indonesia, we are still going to that direction. But we are going there, so it's a good direction, I think. That's my view.
Many thanks for that insight as well, especially with regards to the rationale behind making the law, that the idea of these IP laws is essentially in order to be able to exploit your work and to be able to essentially make money from your creation, from the efforts that you put into creating this intellectual property creation. Many thanks for that. I also want to address a question to Attorney Leslie Tahuk-Orencia, and that was regarding, you touched upon some ethical concerns relating to AI. For you, what is the most, your largest concern regarding the implementation of AI in the Philippines?
Sir, the most pressing concern here in the Philippines now is that we still lack a legal framework that specifies who should be accountable and responsible for outputs created by AI. As a lawyer, I am focusing on these two items, accountability and responsibility. In case there is a transgression, in case someone is harmed, or the right of somebody is violated, who is accountable? Because the difficulty there is if there is no answer to that, that may lead to misuse, abuse, or even evasion from accountability. So I think, sir, as far as Philippine law is concerned, that is the most pressing item that should be taken up as immediately as possible.
Okay, many thanks. So to summarize, accountability is the main concern that you believe it to be. Then I want to address this to all of the panelists and whoever would like to answer. It would be great. Who are the potential actors who could be deemed liable or accountable for AI? For instance, if we talk about a malpractice that occurs from AI, or if we talk about an IP infringement caused by an AI tool, who should we cast the accountability torch onto?
My simple answer is those who are benefited must answer. Those who benefited must answer. So if the AI is created by a corporation, the one answering for any liability must be the corporation. Or if it is developed by a human person, then if there's an injury, that person shall be accountable on that injury.
Many thanks.
Do we have any differing opinions, or would you like to add?
Yeah, I actually would like to add, I agree with your point that
Thank you.
In cases of, especially our topic, robotic surgery, which is a robot created by a human, even though that it is an AI driven, it is created by humans. So in any event there is a malpractice, the one who is creating the robotic surgery shall be liable to, and that's why we are pressing on the needs why it should be filed, why the robotic surgery should be filed, the patent filed in each country, is not like importing the robotic surgery from the US, for example, to Indonesia, to Philippines, to Singapore, and other Southeast Asian countries. So we can actually decide who is liable for that in case of infringement of patent rights. Maybe in cases that the robot has malfunction in it, has errors in it. But however, in cases of robotic surgery, I think the doctor should also be liable, because the robot itself is not entirely working on its own. It has to be controlled by the doctor. Yeah. So it's a case-to-case basis. Yeah. So it might be like the separation of liability between the developer and also the doctor itself in our case.
So yeah, in your case, in a sense, it's the controller, it's the person who's deciding to use this robot.
Yeah.
However, yeah, you have talking specifically about doctors who owe special oaths towards their patients. So that is quite a sui generis case as well. Well, many thanks for your contributions. I want to now give the floor to the audience to ask some of the questions that you may have been bursting to ask earlier relating to any of the topics that have been discussed. Do we have any questions towards our panelists? Yes, and please introduce your name towards the panelists and who you are addressing it to.
Well, I have a lot of questions for everyone, but I will limit them to very few questions. My name is Chad, and I work a lot in AA policy as well. And so I think primarily for Mark, so my first question is like, so you mentioned balance and flexibility. I think these are good words, right? But these are also buzzwords. So I think I was wondering, like, how do you operationalize this? And I was looking particularly for like specific mechanisms by which we can, forward these principles in how the law operates. And I think for the second group, my questions would be, well, first of all, I was thinking when you say robotic assistance or robotic medical operations, I was thinking because there would be variable, it would be different AI. Kinds of AI working on this particular different stages, right? So that would be like AI doing diagnostics, AI actually doing the operations and everything. So I was wondering if it would be helpful if there would actually be like different liability rules for each stage of the process instead of just one general liability which would apply for everything. So I think that would be helpful to clarify what these liability rules. And the second thing is, I was also wondering if, well, I basically answered that particular question, but I was also wondering, is there really a need though to make a new law for this? Because, so, would there not be an existing legal regime for recourse against companies? And I think Attorney Leslie and Attorney Mark also answered this. There could be ways by which people could file, doctors could file against these companies in the current regime. Why would there be a need to now regulate them when there's already existing rules for these?
Yeah, thank you. As to the question for me, I'm encouraging framework that is adaptable, meaning there is already an existing general rule, general framework, because there is already a need for a legal framework as of now. Because if we going to wait for the perfect time, there might be time that you already crafted a framework, but then again, AI already moved on. But we want it to be flexible and adaptable in such a way that you can tweak it, you can adjust that general framework in order to adjust it to the movement of AI technology. Balance, meaning there must be a consideration, the framework must consider the authors and also the benefit for the investors. For the investors, that the money they invested will give them advantage. So it's a way to encourage more and more investment into this phenomenon called AI. And the second question is?
No, the second question is for Anaya and Milo.
Yes. Okay, so I think you were asking about you want a more specific liability rules, right?
Right. No, it was just a thought that maybe it can help you in the future, like specific stages in the medical malpractice rules.
Yeah.
And the question is actually like, but is it really needed though? Because existing liability rules could actually enable people to already have recourse against companies. So why would there be a need for another legislative framework for this? So that's just it's interesting because you need a lot of. So I'm coming from an economics background and law background as well. So my question is always all about the costs, costs, benefits, and looking at how they influence the legislative and judicial process. So that's what I was thinking.
Yeah, so thank you so much for giving us like recommendations in separating legal liabilities. And we know that in this technology, in the robotic surgeries, but our research is focusing more on the robotic surgeries in doing the procedure, not like dissecting on their role in like giving diagnosis. But I believe that there is a robotic surgery, a robotic system that is designated for that area. But I do agree with your view in which in this case, maybe it's best to also analyze that legal liabilities needs to be separated. And to answer your questions as, is it really needed to make a new law? In my view, as a lawyer, I feel like it is needed, like for real. Because if we talk about the robotic surgeries, we cannot entirely blame the robot. It could be the negligence of the doctor, which in this case is already covered under the existing criminal code in Indonesia and maybe other countries. Because the case of negligence, it requires the act from the human, from the person or the doctor operating it. But the absence of rule here that needs to be regulated further and more detail is in the context of digital health. We are still like very much need to catch up on that, because the error from the procedure, it might not be caused by the doctors. It might be caused from, let's say, the inventor. They are okay. You're supposed to insert like 6 like a machine, but they just insert like 5. So it is really under the responsibilities of the companies that is developing that. In which, in this case, if we take a look on the nature of the person that needs to be liable, the doctor is like a person alone, but a corporation it's a separate entity. So that's why, in our view, we need to make it clear that okay, maybe we can sue the doctor or we can sue the inventor, who is probably outside of Indonesia. That's why in our paper we are also encouraging the corporations that like importing, the hospital that import the medical devices, they need also to be aware that okay, these devices is legally protected in terms of patent. They take benefit of this patent system in Indonesia, in which okay, I filed this, so this robot is protected. So in this case, we don't really have an issue on the patent. That's why our research is more of discussing on the legal liabilities. We are not disputing on okay, is this patentable or is this not patentable? Because we are encouraging in that way, but we are in the view that suing a corporation, it's totally different case, because they have a huge system, it's a complicated system to make these robotic surgeries out of the market. So in our view, it is really needed to make a new regulations, and especially if we talk about the regulations revolving around the intellectual property rights in Indonesia, they mostly only cover the physical aspect of any invention. They don't really cover the intangible aspect of the invention. For example, one of the law in Indonesia, which I'm not sure, Professor, if your countries also adopt the same principle. We have a safe harbor principle. Safe harbor principle means that any companies, or big companies, for example, let's say TikTok or any other user-generated content, they have to ensure that every content that they allow it to be put in their system, they have to make sure that okay, let's put a song in our system, in our library. For example, if we talk about user-generated content, the TikTok itself as a corporation, they also have the responsibilities to ensure that these songs is protected and is like based on the perspective of IPR. It is protected and we cannot just let it slide. The corporations, big corporations like user-generated content, they have to actively monitor that the content that they put in their system is protected. Therefore, when the user generating that content, it is also further not preventing for any intellectual property rights infringement from happening. So this principle is also very prominent, and one of the judgment from our constitutional court has expanded the definitions of these responsibilities as to, okay, active role in this case for any corporations is also to expand the responsibilities for not only in the physical realm of any invention, but also we can also extend that to that intangible or like digital aspect of any invention. So that's why I think from my point of view as a practitioners, we are on the view that developing a new regulations, a separate regulations, not only physical, or probably not just like formulating a fresh law, but they have to, okay, amending that, expanding the definition so as to cover this type of inventions. I think that's the view that I can share.
And to add to that, I think the law must be amended because laws must be timely.
Yeah.
It must answer to the needs of the time. So if the law was created 1987, 1938, so there must be a study, there must be an amendment to answer to the call of the time.
Yeah, I agree with you, Professor. Especially that AI is really used. Yeah, nowadays, even though the AI has been here for a long time, but nowadays, for the last 2 years, AI has been increasingly used by the society and the people, especially in law fields too sometimes. So I think it is very needed for us to make a separate regulation regarding, or like amending a regulation regarding the use of AI and other stuff that is related to that.
Yes, many thanks for blessing us with your insights. In light of the time, I just want to ask one final question where I'm perhaps treading on thin ice of copyright infringement, because I'm going to verbatim ask a question that was asked in yesterday's panel, and that is, you can see you've got a room full of mostly aspiring lawyers. What is one bit of advice that you would give to an aspiring legal practitioner as legal practitioners yourself? And I'd like to begin with attorney Leslie Taruk-Orencia.
Thank you, sir. For aspiring lawyers, in the midst of issue as to AI, the most important matter that we should take position is that we should always go for ethical standards. We are ethical lawyers. That is what we always tell our students. And so, in the midst of the interplay between AI art and human art, we should always take the side of what is ethical for that matter. Sir, may I just also, because one of those who asked the questions a while ago asked, why should we walk through this? While I was making that presentation, I was asking myself, should it really be AI art versus human art? Should we always emphasize the conflict? Or is it possible that we give AI art a legal status reflecting its unique nature, without, of course, displeasing the rights of humans? So with that, sir, I think these future lawyers have a lot on their plate. These are very interesting times, and I hope that these lawyers would always just remember that we are ethical lawyers. Thank you, sir.
Many thanks for that great And Tanaya, would you like to give your advice for future legal practitioners?
Oh yeah, so for all of you guys who wants to pursue a career in the legal, such as like lawyering, I think the the one important thing that I realized that it is the most important thing that I may have missed when I was a student is to actually never be satisfied with your research, because as a lawyer I think you really have to be like curious and never be satisfied that fast. So if you have a case and you are trying to resolve this case, one thing that you should apply is to never be satisfied, never be satisfied with your research. So you will keep searching and reading a lot of cases and regulations and many more. So besides of to never being satisfied that fast, I also recommend to just be confident with yourself and don't maybe if you feeling like a little bit not confident, I suggest you that all legal practitioners is also confident. So just be confident and keep learning and all. I think that's it for me.
Then Leila, would you like
My
to-
advice for future lawyers, be mindful that the legal profession is a very important profession. So be ready to do the work and be thankful that you will be given the chance and the privilege to serve as a lawyer. So be persistent, do your work as they said, and believe in yourself that you can do it. You are already here, law school. So few more steps and you will be there. But I wish that you will be an ethical, not only ethical, but smart lawyers in the future. Taking in consideration the needs of the time, the needs of your country, and the needs of the world. The world needs you. So do your work, and you will be there. As long as you have a good intention, you will get what you want. Thank you.
And then lastly, Leila, would you like to give your bit of advice?
Okay, as a closing statement, maybe not really. Just my perspective is, as a lawyer, I would like to say that our voice really matters. So, as I'm handling my experience, I'm handling mostly corporations and international clients. So they came to us and asked, "What do you think about this?" And especially if we are handling cases about tech and about intellectual property rights, they came to us with a new, fresh problem, and it's very technical sometimes. So they are having no clue in terms of legal. So do your research, ask questions, a lot of questions. So it's very case to case, as my colleague also mentions and Professor also mentions, that we have to be adaptable, we have to be strong, we have to have a strong mindset as to, okay, as a lawyer we have to protect the best interest of probably our client, but hand in hand with also the society. We cannot just we cannot just say, okay, your actions violating this is okay because you are a big corporation, so you can you can compensate society in a way that is proper. But that is not always the case, because especially when I said earlier that our voice matters. So that's why, as a lawyer, I think that you have to be careful in giving advices. You have to be adaptable, not only just based on the textbook, but you have to catch up as well in the development of the law. Because if big clients approach you and they are asking about, for example, let's say, imagining that TikTok is approaching you and, okay, our system is like this. And from legal perspective, how do you respond to this? And sometimes as a lawyer, especially when with my seniors in my law firm, they don't really know what this technology is. They don't use TikTok. So they don't really have a proper and comprehensive knowledge in that aspect. So keeping up with what is going on with the world is also paramount in this case, not only just building regulations. So I think that is the piece of advice that I can give, to be adaptable, to catch up with the trend as well, and also be open-minded to receive any, like perspective from other professors or other profession as well, as to give us a more strong and comprehensive standpoint. I think that is all the piece of advice that I can give for today's conference. It is really a pleasure for me personally to be here and to have a discussion with all of you.
Can I add something?
We are running out of time as it goes. But I want to express my gratitude to all of the panelists personally who managed to make it here in person as well as online through this hybrid setup. It's been quite an interesting challenge and honour for myself to be able to chair this panel. I also want to express my personal thanks to Nicholas for his great assistance throughout this whole process, and also to Professor Bagias, who helped organise this conference as a whole. Just to let you know, there are several more panels taking place today on various different topics, so please feel free to attend those as well. Then I also lastly want to express my gratitude towards you for being here and for actively engaging in today's conference. I will do a little bit of shameless self-promotion as well. In third year, we do a minor on intellectual property law, and there I'll be teaching copyright law, and I have a particular week on copyright and AI. So hence I want to give my personal thanks to all of you for your contributions on copyright and AI in Southeast Asia that I can be inspired by through my own classes later on in third year. So thank you for facilitating this.